Okay, well, now that we know that at least all of us are here, it looks like the four of us have our cameras on and other people don't. So that's good. Sorry, folks, we're getting started a little bit late. We weren't able to get on before 3 o'clock, so we're just getting oriented. But welcome, and it's exciting to see so many folks here. I don't know if this is like the last session on the last day, and you made it through. You're still awake after 3 days of the conference, or if you just kind of looked at the calendar and realized you had one more chance to go to a workshop and you hadn't been to anything yet, so you're here. But either way, welcome. I hope we provide good information for a 3 o'clock on a Thursday afternoon. So I'm Melissa Dennis, Executive Director of Community Economics, and we have a great panel here today. I'm going to just talk at you for a minute or two until we get everybody on. Basically, what this session is about is, I'm looking at the names of folks, and it looks like a lot of you are very familiar with the tax credit program. And as most of you know, for more than 3 decades, all of our nonprofit friends have been using the LIHTC program to produce more than 3 million affordable homes nationwide. And it's a system that everyone agrees is an imperfect way for government to fulfill its responsibility to provide affordable housing, because it mixes the interests of nonprofit developers who want to provide safe and stable homes for low-income people in the long term with the interests of corporations looking for tax breaks. And then you toss in convoluted IRS regulations, and you toss in convoluted attorneys' opinions, and you're going to have a system with some potential trouble spots. So it's kind of amazing that for the most part, the structures of these deals have worked. The investor puts in equity up front, gets the tax credits for 10 years, gets the losses from depreciation, interest deduction in a few more years to protect against recapture, and then exits smoothly via an option or a right of first refusal with minimal cash changing hands. But in recent years, we've seen a troubling trend where either the original investor changes their tune when it's time to exit, or more often when they're done with the 10 years of credits and they've gotten the bulk of their benefits, they decide to sell their interest to someone else who has a different agenda and is looking to profit from the real estate. So when year 15 comes around, the nonprofit's ready to exercise the right of first refusal, they find themselves negotiating with a totally different entity with different goals. So we've been seeing litigation over language in the right of first refusal, and in some cases, nonprofits having to pay significant sums to maintain ownership of their properties. So our session today is designed to inform you about this phenomenon, advise you about how to prevent it from happening to you. So we have 3 esteemed panelists with us this morning. Can you hear me? Okay, all right, something happened. I don't know what that was. Did you not hear a whole lot, or did I just stop?
You just stopped, but you're good. You're good.
All right. Sorry about that. Okay, so David Davenport is managing partner at BC Davenport. He represents real estate developers, nonprofit organizations, housing authorities, and other stakeholders in the LIHTC industry and litigation across the United States. He helps clients enforce their rights through litigation and counsels clients on best practices for year 15 contract provisions. Dr. Willie Logan is the CEO and president of the Opa-locka Community Development Corporation in Opa-locka, Florida. He's here to share a case study of what his organization went through in an effort to contain control of the development of theirs. And in addition to his work with OLCDC, Dr. Logan served in the Florida House of Representatives from 1982 to 2000. And mayor of the city of Opa-locka from 1980 to 1982. He's also an adjunct faculty member in the School of Architecture at the University of Miami. And Lauren Fechter, a lot of you know, she's a partner in the firm of Govin Barchet, where she assists developers in connection with acquisition, financing, and syndication of real estate projects using the low-income tax credit, historic, and new markets tax credits. She's also negotiated ground leases, ZDAs, and owner participation agreements on a wide variety of state and local agencies. So what we have for you today is we have David. I'm going to run the PowerPoint, so blame me if you can't see it. David's going to talk through a little bit about kind of setting up the context and setting up the story here. Dr. Logan is going to chime in with his case study. And we're going to go back to David briefly for some solutions, some mitigating factors. And then Lauren is going to tell us about what we need to do to set up projects at the outset so we don't run into these difficulties. So I'm going to ask you, as I think David Zisser in the chat already did, to please put yourself on mute if you're not talking. I'll try to keep myself away from hitting the mute button. So without further ado, let's get into the screen share screen. There we go. And I'm gonna turn it over to David. You can see my screen, right? Lauren, wave at me. Okay. All right.
Yes, I can.
All right.
Can
so David.
Great. Can you hear me okay?
Can hear you, yes.
All right, great. Well, welcome everybody. We appreciate you taking your time and being here to join us for the session today. If we'll go to the second slide, I think it kind of just dovetails into what we just heard from Elisa. There's a historical understanding and practices that has shaped this industry for decades. Just by way of a little background, for the first 20 years of my legal practice, I worked for a large firm in Minneapolis. And the firm had a real large transactional practice. And I'm a trial lawyer. And about 7 or 8 years ago, I was asked to come in and help a nonprofit from St. Paul, Minnesota, with an issue they were having with their right of first refusal. And essentially what was going on was the person who was controlling the limited partner interests at that time was relatively new to the deal, and they had a design on trying to frustrate the debt plus taxes transfer at the end of the compliance period, largely trying to capitalize on a typographical error in the document. We were able to get that fixed and reformed by the court, and then they were able to move on and execute on the ROFR transaction, as had always been the plan. Within a year and a half, I'm now finding myself representing 2 for-profit developers around the end of the compliance period. They're marching towards year 15, needing to exit the limited partner, but they're also needing to refinance the permanent loan, which was at that time tied to the end of the compliance period. And in both instances, we had people new to the deal, and they were essentially holding our clients hostage with their consent rights. They were suggesting that in order to exit, they needed to leverage the property up and cut a big check. And in one instance, the organization went so far as to say, and if you don't, and it goes into hits the maturity date, we're gonna tip you out and issue a default notice. So they literally put in writing, we won't let you refinance, and if you go into default without writing us a check, we'll remove you from the general partner. We went into court in both instances, and we were successful, and we got our client through all of that. Obviously we were in litigation. One of them went all the way to a bench trial, where they were found to be unreasonable and violating their duty of good faith and fair dealing by trying to leverage their consent rights to obtain rights that they could have negotiated for in the first instance, but did not. So we were kind of sitting there. Now I had 3 lawsuits all around the end of the compliance period in the affordable housing industry. And I started doing some research, talking to clients, and essentially figured out what had happened, many years earlier. People had come in and acquired massive interests and control rights in limited partners, investor limited partner, special limited partner interests and deals all over the country. So, we said, well, who are these people? What are they? And what are they doing? Well, they're aggregating interests and control in limited partnerships all over the country. So wrote about it and, talked about aggregators, and that's what they're doing. Then spent a year with a client going to housing conferences all over the country, discussing what was going on, and finding, that people were having similar experiences, similar kind of tactics were going on from the aggregators. And then that kind of takes us to the litigation discussion in the next slide. So we started doing this work back in 2016, 2017. I left the firm that I had been with for 20 years in January of this year, and we started our own firm. My team and I went out and this is just what we do. We represent the general partner side of these deals all over the country, as well as some housing authorities and other public stakeholders who have interest in deals and are being treated the same way. So what we've seen is, these organizations call themselves affordable housing asset management firms, and they're amassing investor interest in deals all over the country. They're treating these partnership agreements as essentially financial instruments, paper investments rather than, really focusing on and trying to promote low-income housing and the preservation of them after the end of the compliance period. So they're attempting to extract maximum value at the expense of the low-income housing and the communities and the people that are designed to serve. And nonprofits are particularly at risk, given the tactics and given what they have in their arsenal if they secured a right of first refusal, which is the ability to get access to capital at the end of the compliance period for the communities that they serve. And we'll talk a little bit more about that. And so what we see is they leverage these economies of scale. They have large institutional law firms that have been around for a long time. They throw a lot of resources at it, and they try to leverage that and the litigation threat, the threat of protracted litigation that'll drain resources and also take up time and create deal fatigue in an effort to obtain significant buyout prices. And so if we'll go to the next slide, we'll give you an example of what a court in Florida found as recently as November of last year. The court has recognized this trend in our industry. And in this particular instance, it involved Hunt, and the court recognized that Hunt is one of these organizations that's attempting to extract value not otherwise intended by the original parties to the partnerships. They have a playbook, and the court identified it and said it's designed to disrupt the year 15 exits to drive a cash return, ultimately to them, that was never intended by the original investor or anyone originally involved in the project. So our judge, he recognized what was going on. And we can go to the next slide. He went on to write that it's more common across our industry, and that the decision here in Florida was in accord with decisions from other similar cases across the country, where they've come into the deals, they're trying to extract value. And he cited 9 cases and 2 sources. So when I tell you that it's happening all over the country, I don't have to believe me, you can believe this court, because it cited 9 cases where this type of activity has been going on. And most of them are cases in which we've been involved helping our clients preserve affordable housing. So then we can go to the next slide, and we'll talk a little bit about the types of things we're seeing in litigation and how that's playing out. One, of course, is the right of first refusal. We'll get into each of these a little bit more in detail. Obviously, that is a unique right created by Congress intended to incentivize nonprofit participation in order to give nonprofits the ability to have access to capital, have access to the resources that they can use from real estate to serve the communities that they provide housing to and other services. Purchase options and option prices, you're probably all familiar with those. They take a variety of different forms. There can be a purchase option to acquire the project or the development at the end of the compliance period. There can be an option to acquire the limited partner's interest in the deal at the end of the compliance period. And those are 2 totally different things. And oftentimes you see people trying to treat them the same way, but they should, if your contract language permits it, produce a different result because you're buying a different asset. We'll get to that in a little bit more detail as well. You see fights about fair market value. You see fights about appraisals. You'll oftentimes see limited partners coming in and trying to say they'd rather use a broker's opinion of value, because that'll oftentimes produce a different result than an appraisal, which can most of the times under these contracts be limited to take into account an assumption that there's going to be continued affordability, for another 15 years and beyond. There's going to be continue to have, rent restrictions. Sometimes a broker's opinion of value may not do that. But I've not yet seen a limited partnership agreement that talks about use of a broker's opinion of value when you're trying to come to a fair market value determination. It seems universally consistent to be appraisals. Capital accounts, liquidation, we'll get into that some more. But essentially what we see is if there's a large positive capital account on the books and records of the partnership for the limited partner, they are oftentimes going to try to point to that and try to monetize that and say that the capital account should be given a direct dollar for dollar correlation. And in some instances, that's millions and millions of dollars. I've not yet seen a case where, a court has recognized the liquidation waterfall as a waterfall provision that overrides what you do with a sale proceeds or residual proceeds or capital transaction waterfall, but just to the opposite. We've had probably 4, maybe 5 cases now, with one we just got affirmed in New York, where courts are not going to interpret these partnership agreements to deprive a use of a sale proceeds waterfall with what would typically be a more favorable allocation of residual proceeds to a general partner. Refinancing, I described a couple of those circumstances. I'm seeing a lot of this right now, just because money's so cheap and the market is so ripe for refinancing opportunities. Seeing a lot of people getting frustrated by their limited partners, unable to refinance without having to fight for it. For a variety of reasons, the limited partners either want to strip the cash out of the refinance, or they want to block the refinance. They don't want there to be decreased costs that might otherwise impact their capital accounts. For sale provisions, we see a lot of limited partners coming in now and saying, go sell the real estate. They really are, in our estimation, in the instances where we're seeing that, trying to do so to deprive the general partner of an option right. They're trying to say that if we exercise a forced sale, you have to assume that there's going to be a sale at a dollar amount that we want, and then run it through a waterfall. Typically, they argue for the liquidation waterfall, and try to deprive the general partner of the option price methodology that might be included in the partnership agreement. Removal efforts, seeing a real sharp uptick in that. It's generally an effort to go in and remove a general partner to deprive them of an option right, because most of the partnership agreements say if you're removed, you lose your rights. Had one instance in Buffalo, New York in November of 2016, where the aggregator showed up with a couple of locksmiths, 2 security guards, an asset management person, and they showed up at 8:45 on a Monday morning and physically tried to take over the property and remove people forcibly from the office. Thankfully, it was in a place just outside of Buffalo, New York, and the maintenance guy wasn't having it. Police came, shoot everybody off, and the case ended up, in protracted litigation. It's pretty despicable, frankly. I mean, that's a 105-unit senior citizen facility in a quiet little area outside of Buffalo, and just imagine, waking up and seeing the cops showing up, pulling guns and all sorts of stuff, and it's pretty despicable. Qualified contracts, we're seeing a lot of efforts to essentially remove the extended use agreements and the regulatory agreements. They're going to keep these affordable after the end of the 15th year, so that when they're going to try to argue for what a fair market value is or what an appraisal should look like, they can say, look, it's coming out of the program, so we want this appraised as market rate if you want to exit us from the deal. So we'll dive in with the next slide into a little bit more detail as far as, some Section 42 rights of first refusals. As many of you or most of you or all of you may know, it's not required that there be a right of first refusal in these deals. The nonprofits need to demand it. They need to insist on it. There are states out there now that may require it, but it's a tool. And you'll see when we get into litigation, we look at what the parties negotiated as far as the terms around the right of first refusal. The Section 42I7 just creates a safe harbor. And it basically says that you're not going to be denied a tax benefit simply because you give a right of first refusal to a nonprofit. So then when the parties are negotiating their deal, what are the terms that they put into their agreement around the right of first refusal? Have they said that there needs to be a bona fide offer? Have they said there needs to be a binding offer? Have they said it needs to come from a third party? What we know in litigation is a lot of the deals that were done many, many years ago, they didn't really put a lot of terms around them. Sometimes they did. Other times they put, basically if you get an offer, or if the partnership decides to sell, or if you receive a commitment, there's a variety of different things that are in these agreements. In litigation, what we see is if there's no real hard conditions in place, the aggregators will argue that, well, common law should imply them into the deal. So even though the agreement doesn't say it needs to be a bona fide offer from a third party, they come in and sue and create litigation and argue that the court should create it through common law that might exist in a particular state. They've had a little bit of success in a couple of cases that way. they've not had success in some cases. As I mentioned, the common bond case in St. Paul that we did very early on in this space, we formed a third-party affiliate of the nonprofit, and it made an offer, and it triggered the ROFR. It was consistent with what was permitted by the partnership agreement. Nobody challenged it. Everybody just moved on, and we had a fight about whether we could buy. So, you have to be very mindful, and Lauren will talk about some of this stuff when she gets into the drafting. They'll also yield their consent rights and claim that, well, we have consent to the ultimate sale of the asset, so we're not going to consent to approval of a letter of intent if it comes in from a third party to buy. There's been at least a couple of decisions where the courts have said we're not going to allow consent rights to be utilized to make meaningless and deprive the nonprofit of its right of first refusal. Because obviously, if a limited partner is hoping to get a market rate or fair market sale, as opposed to a transfer pursuant to a ROFR execution for debt plus taxes, they're never going to consent. And so it becomes this illusory right that the nonprofit can't accomplish. I think right now the leading case on the consent rights was the one that came out of Massachusetts several years ago. It was the homeowners rehab case. And it went all the way up to the Massachusetts Supreme Court, and the court affirmed the decision in favor of the nonprofit. Like I've said, though, there's been a couple of cases that went the wrong way. One of them is in New York. It's up on an appeal. There's one in Michigan in federal court that's currently on appeal. We were engaged recently to take over that case, and we got that appeal filed about a month ago. So we'll see where that goes. You'll hear more from Dr. Logan about our experiences with him and his organization in Miami-Dade County. They had a ROFR execution, and it went well, despite a year and a half or two of litigation and a significant drain on resources. But ultimately, we got the right outcome. It's currently on appeal. So we can go to the next slide, please. Purchase options and option prices. As I mentioned, they take on different forms and should produce different results based on the language of the partnership agreement. They may not, but at the end of the day, what does your agreement say? What is your option? Can you buy the property or the interest of the limited partner in the partnership? The property obviously is an asset of the partnership. So you're looking to buy, and have a fee simple sale. Now the execution might be an assignment of interests, but it's supposed to be oftentimes modeled as a sale of the property. When you're going to buy a limited partner interest, you're not having a transaction with the partnership. You're having a transaction with the limited partner based on the value of its interest in the partnership. So depending on the language of your partnership agreement, it ought to be the case that you value the economic rights attendant to those interests. What are the cash flow streams? What are the fees that the limited partner receives going out into the future after the sale? Discounted cash flow analysis works quite nicely because that's what you're looking at. Now, we all know at the end of the compliance period, those interests typically don't have cash flow fee streams that are very significant, because the economic benefits that the limited partners were striving to obtain were tax benefits, the credits and the losses that are no longer available from a credit side at the end of the compliance period. I mentioned earlier the disputes around the BOVs, notwithstanding what the partnership agreement might require. The big one really that we're seeing a lot of in litigation, again, is demanding that the positive capital account be returned through a cash payment. They oftentimes argue that Section 704B requires such treatment. Don't agree. We need to look at what the partnership agreement says, and what does the partnership agreement provide in terms of how the option purchase price should be calculated. There's an exception in 704B that relates to an arm's length transaction between parties and partners that would take away any concerns about a substantial economic effect. But at the end of the day, even if people want to reasonably disagree about what Section 704B says, the contract controls. And if it turns out that there's some tax implication to the limited partner, that's their problem. They negotiated the deal, and you don't get to say, well, I don't like the deal now because I have this tax consequence, and I want you to change the agreement and monetize my capital account. If the contract doesn't require it, it's not supposed to happen. And so what you see a lot of is this conflation of what happens when you have to model a sale. If we do a hypothetical sale, what does the partnership agreement say is supposed to happen with sale proceeds? It's nearly universal when you have a separate liquidation waterfall that accounts for positive capital accounts and a sale proceeds waterfall that does not account for positive capital accounts. You're going to model the sale. You're going to then distribute proceeds from that sale. You're then going to look and say, okay, what happens next? Well, we just sold the principal asset of the partnership. Our partnership agreement tells us that that event was one that caused a liquidation to now occur. And so we then liquidate what remains after the sale proceeds have been distributed. So far in each case that I've been involved in and that I'm aware of, when the aggregator argues, no, you need to skip over the sale proceeds waterfall and treat those as liquidation proceeds, they failed. And most recently in New York, we had a unanimous decision from the Supreme Court, Fourth Department Appellate Division in New York that affirmed just that outcome. If you're going to redeem the limited partner interests based on a hypothetical sale, you don't give account to positive capital accounts unless the contract requires it in the residual proceeds, sales proceeds waterfall. The court went on to say that even if it was a real sale, you don't change it. It's still the same outcome because you distribute hypothetical proceeds just like you would real proceeds from the sale. And in that instance, I think it was an 80-20 split for the general partner. And then you say, okay, now you go off into liquidation, but you don't conflate the two and put the cart before the horse. The last kind of dispute I mentioned earlier about valuations, assuming dissolution and asset liquidation. So just to give you a little bit of flavor of some of the things we see when we get into litigation, we can go to the next slide. We had a case just outside of just outside of Seattle in federal court. Oh, I skipped over, my mistake. The recapitalization opportunities. This is what I mentioned earlier about trying to force consent rights into leverage. It creates a Hobson's choice, right? What are you going to do? Am I going to default? Or am I going to pay them? We've seen people leverage those recapitalization opportunities insofar as they say, we'll exit, but we want to participate in the resyndication opportunities after we exit. In a case I'm going to touch on here in a second, we literally had the aggregators telling our client, we believe when you resyndicate this asset a year from now, this is what it's going to look like. So give us 50% of the upside of the resyndication and we'll exit. It doesn't work. And in that instance, it didn't work. And so we get into this litigation. Now I think that's right. We can go to the next slide. So you get into litigation and what do you see? People start having their emails exchanged, produced, evaluated, looked at, and you start to see, in this particular case, it was out in Seattle. There were 3 affordable communities in play. A 4th one came in later. And essentially our client was DASH, Downtown Action to Save Housing. They were in a deal where the Midland portfolio had been acquired by a group out of Boston. And you can see here that they're internally at the Boston group, they're internally trying to figure out how they're going to leverage this nonprofit and how they're going to, look at the options, what they're going to try to do. And they're writing about, the GP on the deals has this option. And then it says they're a small nonprofit. They might just be able to pay us off to get rid of us. However, maybe this deal will be a bit small for most other syndicators. I'm trying to find a way to boost residuals and get you a deal worth doing. And I find myself threading a pretty fine needle, but I don't feel like I'm way out in fantasy land. So this is an internal communication designed to figure out how to go squeeze this nonprofit. And it turned out that he was living in fantasy land because they lost. And what ended up happening was we had an option to acquire the limited partner interests rather than executing on a ROFR it became a better transactional cost. So we were entitled to exit them out of 4 deals based on a discounted cash flow analysis and lots of debt and lots of restrictions and various land leases. The appraisals came in and said we should be able to acquire their interest based on a discounted cash flow analysis for about $70,000. And they obviously wanted more. Leading up to the litigation, they were asking for over $1 million. We get into the litigation, we went on summary judgment, but we have damages. As you can imagine, if you can't reposition your asset at the end of the compliance period, if you've lost an opportunity to resyndicate through 3 rounds, if you've lost an opportunity to refinance, because most banks aren't going to touch a refinance if you're in litigation, we had a few $100,000 worth of damages, and we were going to go to trial on damages. But ultimately, they walked away. They handed us the keys. They said we'll forfeit the money that we were supposed to receive had we done what the contract required us to do. So off we went. And finally, now these assets are being resyndicated. During the litigation, one of the properties, Ashwood Court, a senior facility in Bellevue, Washington. The decks were failing. You had rotting situations, so nobody could access their decks. We just had to wall them off because we didn't have the money to spend the decks. And of course, they were holding us hostage in litigation. We can go to the next slide. I've already talked generally about the GP removal efforts, but those were touched on already. So go to the next slide if you would, please, because this is another example, basically coming straight out of litigation. The case that I mentioned to you earlier where the court found this troubling trend in our industry, one of the things that the court did in one of its orders, now if you could go back, please. In one of its orders, it found that my client, CED, had committed no default. What happened in that case was we were trying to exit the limited partner. And under that deal, it was a 90-10 split, and we modeled it as a hypothetical sale. We got the appraisals, and we were supposed to pay $1.6 million to exit the limited partner. But that wasn't enough. The aggregator wanted to monetize a positive capital account, and they were saying, you're defaulted. You did some things a couple of years ago. You shouldn't have done them. You're out. They were trying to kick us out because the affordable housing properties was worth like $30 million on a fair market appraisal. So if they can kick us out, they can become the owner. They can do what they want. The court found that those allegations of default were baseless and intended to deprive my client of its rights. And ultimately, we prevailed. Summary judgment on liability. They were found in breach. We had the damages trial. And as a result of the damages trial, we had a lost opportunity cost that we were deprived of. So the court awarded us roughly $1.3 million in damages with a per diem loss of $2,000-3,000 a day until the case is over, because they don't stop. They just keep going. They appeal. They do whatever they can to leverage. And so we went down to Florida 2 weeks ago and had another hearing, this time for attorney's fees, because this partnership agreement allows the prevailing party to recover its attorney's fees. We asked the court for, I think it was $875,000 in attorney's fees that had been incurred in the 2+ years of litigation fighting over this. They took the position that our attorney's fees were entirely unreasonable and we spent too much money and blah, 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 blah. So when they did that, they had to then turn over their legal bills. And we quickly found that, they were $1.6 million into it. So I think our fees were, relatively modest in comparison to theirs. But some would certainly rightfully say that it was still very expensive. But the per diem damage amount now has, accumulated over the course of the last year, such that the purchase price will come back to our client. It's been held in escrow at the courthouse because our damage amount is now like $1.8 million, and there's $1.3 million purchase price. And obviously, if the court awards us, the attorney's fees we're looking at, we stand to have $1 million judgment against the aggregator, and we've been owning that asset now since April of last year. And so when we talked about the aggregator playbook, the second little quote you see on the screen there is from a case in Tacoma, Washington. involving another for-profit developer. And they talked about this accounting process where Alden Torch does a deep dive into the financial statements dating back to 2002, 9 years before they had any involvement in the deal. And essentially what they're doing is they're going and looking for anything that they can to say you made a mistake. And that's what they did to this poor woman, Miss Tamarindo. They went back to 2012 and said, here's everything you did wrong. You're a horrible, horrible person. You should be removed. You're terrible. Court didn't buy it, and they failed. But if you ever talk to her, just imagine, sitting up there and having people tell you after being in affordable housing for 25 years and having no one ever challenge how you did your job or how you did your deals or how you delivered your credits, that you're a horrible, horrible, horrible person. But that's what they do. We could go to the next slide, because I think you'll see, what can you do? And we'll talk later after the case study about some of the things that are going on from a policy perspective across the country. But we're seeing housing authorities now taking action and recognizing what's going on. And Washington State Housing Finance Commission, I think, was the first. They issued a white paper in the fall of 2019. I think it was fall of 2019. It might be 2018. If you want to see that or any of these other things that I'm putting up on there, shoot me an email, give me a call, go to our website. We have a resources tab, we have a news tab, where you'll start to see a lot of these things if you're looking for those kind of resources or trying to figure out a way to become part of the solution.
And the white paper, David, is there's a list of resources at the end of the PowerPoint that will list, it has the white paper as one of the list. So
great, thank you. So what WishVic did was, they put these transfer requirements in place so that they need to consent. And part of the idea was, the commission wants to be able, from a policy perspective, to curb this, prevent this. And Alden Torch's response was to sue the commission and all of its commissioners. And that case is currently going in federal court in the Seattle area. In Massachusetts, earlier this year, they did a NOFA, Notice of Funding Availability, and they just came out and said, look, you're not going to be able to qualify if you've been involved in aggregator activity. If you're trying to undermine the exercise of a LIHTC ROFR or first option, and it goes on to talk about, lawsuits, you're just not going to be eligible. So this is a really solid step in the right direction. If we can go to the next slide, and you'll see that we've come up with 10 red flags with the collaboration of Leading Age, which is a large provider of it's an association for providers of senior housing, and also with the National Housing Trust in Washington, D.C. The three of us got together and we created this red flags document. The idea is, helping to create awareness and helping people, if you have any of these red flags in your deals, you may have a problem. One of the principal concerns is who's your partner? Has the interest changed hands? Are they still the same today? You should know. That is becoming increasingly more important, but I will say that I am getting more and more phone calls within the last year and a half from people saying, gosh, I don't have an aggregator in my deal, but boy, I have an original investor, and they're certainly starting to act that way, or they're talking to me in a different way and we're starting to see more traditional investors, I'll just say, put the squeeze on, if you will. So the second red flag, who's managing them? Are those organizations involved in litigation? Are they these asset management firms that came in and acquired the right to manage the investor limited partnership funds? The next one is if you've got large positive capital account balances and the investor limited partner is trying to monetize that, starting to talk to you about a cash out process. Another red flag is the investor limited partners talking about future planning, future values, future circumstances, like refinancing or resyndication as a means to buy them out. We oftentimes say, if you're going to sell your house, move out. And what the new owner does with it after you're gone is none of none of your business. So, if somebody is looking to figure out how you want to position this asset after they exit, I would just respectfully understand why, because they really shouldn't care if they're exiting in good faith. The fifth red flag, efforts to restrict or limit use of reserves, withholding approvals for project needs. We literally had to start litigation in Chicago to get people's attention and get the court's assistance to repair elevators at the senior housing facility because the soon to be exiting investor didn't want reserves to be used to repair the elevators for grandma and grandpa. They wanted the reserves to be super high so that they could cash out and take them with them on their way out the door. Excuse me. The routine financial reports. This is the deep dive. If somebody starts talking to you about a forensic audit of past events, you're probably going to have a problem. The second, number 7, exit negotiations stall. You experience non-responsiveness. You'll see sometimes people just trying to run the clock out on you, and you should be aware. Number 8, qualified contracts suddenly pop up. Number 9, people start talking about liquidating the partnership. And number 10 is probably in reverse order, could be number 1. If you're not adequately familiar with your documents and you're talking to or fielding questions from your investor, you probably have a problem. It's really incumbent upon everyone to know their deal, everyone to know their documents. It's very common and understandable for people to say, look, I did this deal 15 years ago and I put my closing binder on the desk. I know what my deal with that person was. I know what's supposed to happen at year 15. What do your documents say? And what are a group of lawyers from large institutional firms across the country representing the other side going to come in and say your documents mean when they read them, as opposed to what you think they say and what they probably do say. But you're going to have to be mindful of timing. You're going to have to be mindful of what your option rights are, what your right of first refusal time periods are. So don't be caught in a situation where you don't know your documents. And I would say in that respect, you really should give thought to essentially creating checklists, right? If you don't already have the institutional documents and the processes within your organization, there's pretty easy ways to get that in place. But you do have to commit some resources and some time for somebody to kind of sit down and figure out what the thresholds are, what the checkpoints are along those lines, so you don't lose your rights. So with that, I think I've been going probably long enough, Elisa, and then maybe I can turn it over to Dr. Logan.
Thank you, David. And hello, good afternoon, everyone. First, let me say how much I appreciate the work that David has done both for Opelika CDC as well as the industry. If there's any question why we retained him to work on our behalf and in some respects to represent the industry in facing issues such as he's described, if there's any doubt at this point, let me assure you there shouldn't be. And I think that's partially why we won our case on the trial level in summary judgment without having ever to go to a trial. I'm Willie Logan. I have represented the Opelika CDC for the past 41 years as its CEO. Miami-Dade County has really, really grown over the past 20, 30 years to become a metropolitan, an international city, one which there is a large gap between the have and the have-nots because of international investors, wealthy individuals coming here for second homes, and because of the fact that tourists and the service industry is a huge industry in Dade County, which pays very low wages, as well as is not located in the areas of many of their workers. So affordable housing is a huge issue in Miami-Dade County, as it is in many places, but it's exacerbated by the things that I've mentioned before, the international investors, as well as the low wages. And so many folks in Miami-Dade County found themselves priced out of paradise. The next slide, please. What we're going to talk about, what I'm going to share, and I'll try to be brief because I'm really interested in hearing from our audience. I appreciate so many people on a Thursday afternoon on the last day of a conference to still be with us. We think that we're an interesting community, not just because we're located in Miami-Dade County, because the city of Opa-locka itself is very interesting. It has a lot of Moorish architecture, the largest amount of Moorish architecture in the country. It was developed in the early 1920s. And it really, after World War II and the GI Bill for veterans of color being able to get, veterans of color being able to get federal insured mortgages, Opa-locka became a suburb of the then segregated communities throughout Miami-Dade County. And it's one of the oldest communities where Black middle-income families were able to move, to own homes and to live. The next slide, please. The city of Opa-locka, though it started off as a upper middle class community in the 70s and 80s, as you begin to have white flight, as you begin to have horrific zoning, and as you had lots of refugees or immigrants coming to the United States to find work and to find opportunity, moving into the city of Opa-locka because things are relatively cheap there compared to the rest of the county. We found that the average income, the educational level, the amount of poverty, folks who didn't speak English, et cetera, grew over the past 10 to 20 years that have created an environment where you have a very low-income community this consists of only 16,000 people, but it's surrounded by another 100-some-odd thousand folks that are in unincorporated Dade. And so the city, in many cases, represent these folks. The next slide, please. So Opa-locka Community Development Corporation, quite frankly, came about because there was no community-based organizations representing the residents in the city. There was a real need for community development and not just affordable housing. Opa-locka CDC's mission is really to create a strong ecosystem that supports under-resourced communities in creating equitable and sustainable economy. So in addition to affordable housing, we have a CDFI, we have a CDE, and so we participate in small business lending. We participate in providing equity to businesses, community-based organizations, et cetera. We have a lot of service programs. We have a lot of after-school tech and art programs. And so we do more than just affordable housing. But why affordable housing is important because it provides the foundation both for families, but it also provides earned income for community-based organizations that help it to bring about change in the community. Next slide, please. So what we're really going to talk about today is the As-Run project, but just so you can just get an understanding, as we look at how do we sustain ourselves as an organization, how do we provide services to the residents in the communities that we serve, we cannot just depend on government and foundation. It always, my mother always said, child, bless the child that has its on. And so we operate in an environment that allows us to have earned income as well as to get both philanthropic foundation and government support. But what pays our bills, what assures us the ability to plan for tomorrow and to fight aggregators, for example, is the fact that we do have earned income, and the creation, the development of affordable housing is one means of doing that. And it probably represents about 80% of our earned income. And so if we go to the next slide, I'm going to talk a little bit about this particular deal, the importance of the ROFA, the importance of low-income housing tax credits. So we saw when low-income housing tax credits is providing equity to develop affordable housing was really, and because it had to set aside for not-for-profits, as well as it had the Section 42, we saw it as a means to create a sustainable organization that also had the resources to invest and provide services in the community. We recognize that oftentimes when these deals were developed, outside of the development fee, we really did not benefit from the cash flow, oftentimes from the subsidies that we brought into the property. Oftentimes we owned the original property that came into the deal, but we didn't really benefit from the cash flow the first 15 years, 10 to 15 years, because most of that money went to the limited partner, or in our case, if we had a joint venture, went to the managing general partner. And so it was always our thought and plan that at year 15, it would then be our turn to reap the benefits from the development of this particular property. And so Aswan was built in between the year 2000 and 2004. It was a dilapidated housing development that had been abandoned. The CDC acquired the resources to purchase the property, to demolish the property, and then we joint ventured with Bank of America CDC in order to develop the property. We accessed low-income housing tax credits from the state of Florida. That was part of the 10% set-aside program that allowed not-for-profits to participate in a competitive situation where they're only competing amongst themselves. And so this money, these tax credits would not have been accessible without the not-for-profit. We also brought in a little over $2 million of monies from the county as well as the state of Florida to help subsidize the development costs and to ensure that it would be a profitable venture as we move forward, and also to ensure that the equity that was in the property at year 10 and 10, 15, all wouldn't been eaten up by first mortgage because of the subsidy that we brought into the project. And so, next slide, please. And so we were moving along. As you can see, it's a beautiful development. We were moving along. It was our plan that in year 2017, we would start gearing up in order to prepare for the exit of the limited partner, as well as our managing general partner, which was Bank of America and Bank of America CDC. We had begun talking to the Enterprise, which was the asset manager for Bank of America, and beginning to gear up to get ready for year 15 when the limited partner would exit, as well as our ability to become 100% owner of the property, refinance it, and then eventually re-syndicate it and reap the millions of dollars that would be available to us because of the investments and work we had done over the past 15 years. But to our surprise, in 2014, both Bank of America, the limited partner investor, and Bank of America, the CDC, decided without notice that they were exiting and exiting early, which the law allows them to exit as early as year 10. Because we thought we had a partner, because we knew the bank depended upon CRA credits and other regulatory requirements, we never suspected that the bank would be a party to not only bringing in an aggregator, but also not really working with us in a true partnership, or even providing the evidence to us that the value of what we had. Fortunately for us, we knew. Also, fortunately for us, we had a ROFA in our original agreement with Bank of America. So Harlequin comes in out of Boston, no question of aggregator. They've never built one single unit of housing. They come in, they invest little money, they become the asset manager as well as the property manager. They reap hundreds of thousands of dollars a year from both being the property manager, the profits from that, as well as from the cash flow. And in this case, they invested somewhere between $250,000 or $400,000. They have not revealed what that was. The property at that point in time was worth $14, $15 million. And so You know, how can someone who invests $250,000 or even $400,000 and then make $400,000 a year for being a property manager and asset manager think that they should have access to the equity that is developed in the property? And so they did just what David had said. They started doing things that alerted us to the fact that they were attempting to refinance, to exit, and take away part of the equity, or in this case, I think they wanted 51% of the equity that had developed in the property. And of course, we were alerted to this because we had done everything that David said you should do. We had a tight agreement that not only referred to the ROFR, but spelled out what the ROFR meant. They had tried to take it out when they came in 2014. We refused. They asked us to put in a clause to say that if we decided to sell without their consent, then we would then share 50% of the proceeds. And so they understood that we had the ROFR. They understood what the ROFR meant. They tried to take it out. And at the same time, now they're denying that the ROFR had any meaning whatsoever, and that in April of, well, let me just go back a little bit, and then I'll bring this to a conclusion. In January of 2019, this is 2019, they came to us and they said, look, we recognize that there's $18, $20 million of equity in this property, minus the loans that you all hold. We're talking to folks, seeing what opportunities there are to refinance this, to maybe bring in an investor, et cetera. And we'll be back in touch with you. Well, to us, that's a red flag, red flag, red flag. And so we began to assemble a team, including legal counsel, to prepare us for what we knew was coming down the line, which was a legal battle, because we knew they wouldn't just walk away. In April, we received a letter from them, a letter of intent, as well as an email that says, we have decided to sell our interest in the property to ABC Company. And in order for us to execute this deal, which we've already signed, we need you to sign this letter of intent. And if you sign this letter of intent, we think we will be able to close within the next 9 months. And these are what we expect the proceeds and the windfall to be. Well, we saw that as our ability to execute the ROFR, which we did. So within 45 days, as designated within the statute as well as our contract, we informed them that we agreed to the letter of intent to sell the property. However, we were executing our ROFR, and that we had 45 or 60 days or so to close. Well, right after that, they wrote back to us and they said, and you can go to the next slide, please. They wrote back to that, and they wrote back to us and said, oh, no, we were just kidding. We weren't really serious. And we really think you guys misunderstood what our intent was. We understood then that we needed the best trial attorney in the country that was knowledgeable and experienced in this deal. And we discovered and found David and reached out to David. And to just speed it up, even though I'll say this, and it's my opinion, the judge, the trial attorney agreed with us that they understood exactly what the contracts stated that they signed. They understood exactly what our rights would be if they did what they did. But despite all of that, they thought that their money, their influence, time will force us to our knees and to bargain some deal with them where they were willing to take some of the assets in cash that was really belonged in the community of Opelika, not to investors or some investment firm that was based in New York, but may have had investors all over the world, that money should have stayed in the community. And so it was not just about retaining affordable housing, but it was also about retaining the asset as well as the cash that came from owning that asset for 15 years that would allow us to build additional affordable housing, make additional investments within the community, provide additional service within the community, as well as assure the future of the Community Development Corporation. And so the ROFA is not just about preserving affordable housing. It's about who owns the asset, who owns the equity in the asset, and how that money can be deployed to continue to bring about improvements within the community versus going to individuals outside the community to do what they want to do with. So we won after all kinds of depositions, all types of hearings and motions, and all type of tactics that have made us spend over $1 million in order to defend our rights. On July 7th, we prevailed in summary judgment. The court agreed with every single argument and point that we made. The defendant appealed. They asked for a stay of the lower court decision. The lower court denied the stay. And then the defendant began through their attorneys to make it almost impossible for us to close on the transaction. And it was from everything from informing the bank or other lenders that they were going to appeal and therefore they shouldn't do anything on this transaction, to actually reaching out to title companies to make it difficult for us to find a title company. And I can go on and on and on. And so almost 1 year to the date after the judge ruling, we finally have a closing date, really the week of July 5th. But we are assured that even though now we have everything that we need, that there will still be something to come up to try to attempt to keep us from closing. So, and my last comments, if you go to the next slide, quite frankly, has to do with a call to action. David has already talked a little bit about that. The next presenter, go to the next slide, please. The next presenter is going to talk about how do you protect yourselves. And so we really do believe, and David has said this, is that you really have to negotiate from a position of strength. So you got to bring something to the table. So if it's a zoning, if it's local subsidy, if it's a set aside for the tax credit program, if it's the political relationships with the community to be able to get support, but you got to bring something to the table. And you got to always negotiate with legal counsel who understands the definition of ROFAs, who understands affordable housing, and who's prepared to ensure that from the beginning of negotiation, from the LOI to the MOU to the actual partnership agreements, that you are cognizant of your rights and you're negotiating from a position of strength, and you insist that you have a ROFA and not just make reference to the ROFA, but spell out what the ROFA means, what the intent are, and ensure your success with litigation. And I also would say this, is that until there's some national fund to support community-based organizations to preserve the affordable housing, that I hope someday folks like OPLOC and CDC, that we hope to be successful, and others will be able to put the resources together to help the smaller organizations who don't have the resources to fight these aggregators to do it, because money staying in the community is more affordable housing, more services, and empowerment of the residents. And so with that, I'm going to stop. I know there's another slide that talks about specific action, but I think some of that's going to be covered. To the extent it's not covered, we can talk about that during the questions. Thank you all very much.
Thank you, Dr. Logan. And just before we get back briefly to David, and that briefly is a clue, David, and then get to Lauren. I wanted to just ask folks, if you have questions, to go ahead and put them in the chat, and we'll monitor the chat as we're going along. There was one question that came up, Dr. Logan, while you were speaking, and somebody was asking about Bank of America and if they had any interest or comments or regrets or anything for their part in initiating this disastrous process.
We have not heard from Bank of America. If I was Bank of America, I would be nervous. We first need to get through this current litigation and the current appeal. and we need to close on this transaction, and then we need to get back into the trial court level to deal with damages. Once we're done with that, we will deal with Bank of America.
Okay. Okay, thanks. So let's see. Oh, is this, where are we? Okay, there. So this is back to you, David. So yeah, so briefly back, David, please put any comments or any questions in the chat, and we'll monitor those as we go along. We're going to hear briefly back from David about some things that the industry and some states are doing, and then we'll get to Lauren about how we can protect ourselves going forward or starting off. So back to you, David.
Sounds good, thanks. A couple of these things we've already touched on, so in the interest of time, I'll go to the next slide.
Yeah.
Oh,
sorry.
That's okay. Right there. You know, I think it's really helpful. You know, I don't know if incumbent is the right word, but you know, if I can offer my opinion, I would say it's incumbent on the HFAs and commissions to really think about ways that they can weigh in. We saw what Wishvik's done. You know, we saw what done in Massachusetts. I know in New York, HPD's kind of looking at doing some things. I think they already have actually. But you know, approvals, minimum standards for ROFR agreements. You know, working with nonprofits, maybe creating some resources, some webinars, some seminars. You know, to help educate nonprofits about what is available to them. As Willie said, there's a lot of smaller nonprofits out there that are not necessarily capitalized in such a way to deal with what might come in the future. If we could go to the next slide, there's clarification efforts underway up on Capitol Hill to maybe make some amendments to Section 42, reference to property, making sure that includes all assets of the partnership. That's important so that, reserves are capable of staying with the property. Some states certainly require that, but not universally. Efforts to talk about investor consent not being required for a ROFR to be exercised. Efforts to say that, look, a bona fide offer isn't required. It can be any entity, including a related party making an offer. The idea behind the legislation that's being proposed is to confirm that this is supposed to be an easy, efficient transfer to get the resource to the community, to the nonprofit, so that they can effectuate what they need to within their community. When the ROFR works as intended, it is a remarkable tool to improve communities all over the country in need of access to equity and services and more affordable housing. It touches on all sorts of issues for racial equality, racial opportunity, breaking down barriers in terms of access to capital for communities within our country that have been largely marginalized. And the program is designed to help create affordable housing for those people. And then 15 years later, they can have access to the equity. And it's a wonderful, wonderful tool. There's a pretty significant resistance by the aggregator community up on Capitol Hill. Lots and lots of lobbying efforts to resist it. And so we'll see where it goes. The intent is not to supersede express language in existing agreements, because you can't do that, right? I mean, if you have a deal, your deal is what your deal is. But if we can prevent this on a go forward basis, we feel like it's incumbent upon us to be part of the process. So the last slide I think that well, it's just a couple. Yeah, the last slide I think I have really is that one. and I probably need to go ahead and turn it over now.
Thank you. Thank you, David. Thank you, Dr. Logan. Thank you, Alyssa. And thank you to you all for being here. Bear with me, it's 7:15 on the East Coast, and I'm following a litigator and a very exciting project story. So my goal, honestly, is to get you to avoid a meeting with David and not have a horror story like Dr. Logan's. And two things that actually each of them said really resonated with me. The first, David said, is read your documents. That is 100% true. Your counsel is there to protect you, but it's really a partnership. We want you to understand what you're agreeing to. And then the other thing that Dr. Logan said that really resonated is involve your counsel at the beginning of the negotiations. And I would really like to stress that, you know, it's really helpful if we're involved day one at the LOI stage, so we can begin helping you to strategize and really, you know, think about these issues and frame them. So I'm going to take a step back and just sort of briefly touch upon year 15, which is the end of the initial compliance period where there's no longer a risk of recapture. And so in an ideal world, you have the general partner goal to sustain and preserve the affordable housing property. And you have your limited partner goal. They've earned their credits and they want out of the deal. Where we go sideways is, you know, what David has explained, where these aggregators basically want to capture residual value. So I'd like to help protect against that. Alyssa, if you want to go to the next slide. So let's first talk about the right of first refusal. And so post 1989, the code was revised to say that a property could be sold to a nonprofit for a price, quote, not less than the minimum purchase price. So what exactly does that mean? The minimum purchase price is debt plus exit taxes. Some investors will require an adjuster for unpaid tax credit benefits, and this ultimately may end up being higher than fair market value. Next slide, Alyssa. So how do we protect ourselves in the right of first refusal? I think the first sort of important thing to note and document is that the property should include all assets of the partnership and that the reserves clearly should stay with the project. This encourages sustainability of the project long-term. One of the other sort of things that we should add is that investor consent should not specifically be required to exercise the right of first refusal. There should not be any investor conditions. One of the things that David touched upon is the bona fide offer. And frankly, we've been trying to negotiate this up front in the LOI. Obviously, your LOI is not going to include every single term, but this is a big one. So a bona fide offer should not be required to exercise the right of first refusal. And any entity, including a related partner, should be able to make an offer to trigger the ROFR. The backup position, because some investors will not allow you to do this, is to add language that says that a bona fide offer will not be required if there is an acceptable IRS ruling, legislation, or other guidance that's subsequently provided. Ideally, your ROFR should include the right to purchase each of partnership interests and or the property. And that note that the statute only addresses the project, but many investors will allow you to purchase their interests as well. If the investor requires a forced sale, that should be subject to the right of first refusal. Note that there's no statutory requirement that a right of first refusal be limited in duration. Most investors will insist on a time limit, and what I typically have seen is 1 to 3 years following the compliance period. We typically request that a minimum 2-year ROFR period starting at the end of the 15-year compliance period, and with sufficient time to exercise following an offer, typically around 60 days, and thereafter sufficient time to close, around 6 months. Then we also have another exit mechanism known as the purchase option. The purchase option price is typically the greater of fair market value or debt plus taxes. And if you negotiate an option to purchase a limited partnership interest, typically the greater of fair market value of the partnership interest or unpaid benefits plus exit taxes. Exit taxes are triggered when the investor has a negative capital account, which results in a gain being recorded since the benefits exceeded the investment. If the investor has a negative capital account in year 15, a gain will be recorded since the benefits exceeded the investment. And this would trigger exit taxes, which is taxable income to the investor, and payment of exit taxes by the general partner creates yet another taxable event. Next slide. So how do we protect ourselves with the purchase option? Typically, we ask for a waiver of limited partner exit taxes, or we request that we only be required to pay taxes above those projected at the closing. If we are required to pay exit taxes, we want to make sure that we have the right to exercise the option prior to year 15 if you have any concerns about a negative capital account. In this instance, if you're going to have an exit prior to year 15, because it's before the end of the compliance period, many investors will require some sort of guarantee to mitigate the risk of recapture of tax credits. In terms of negotiating what a fair market value appraisal looks like, we always ask that the nonprofit has input into the appraiser selected. And if reserves are to be included and considered in the appraisal price, the appraiser should consider restrictions on them. The last point is to request 94% of fair market value, which reflects a 6% deemed broker's commission discount. And then just as an aside, I would also recommend working closely with your consultant, like Alyssa, for example, to run your numbers so you know what you're looking at and what the risks are. Are exit taxes projected to be high, et cetera. So again, I recommend not only involving your lawyer early, but your consultant as well. Okay, another exit strategy is the put, which is the limited partner right to sell its interests, which is typically a nominal amount of anywhere I've seen from $100 to $1,000. And how to mitigate the risk with puts is to request that these exclude general partner obligations like unpaid guarantees. And the big issue lately with partnership agreements, a lot of investors are now asking, it used to be that when you transferred limited partner interests to non-affiliates, the general partner oftentimes would have complete consent. I think, Dr. Logan, this would have protected against B of A transfer. Now, a lot of investors are putting in their partnership agreement that once all of their capital is in, they should be allowed to transfer to whomever without any consent. And so we're seeing now transfers to bad players because investors want out. And so this has been a real point of contention, and we're working very hard to negotiate ways to make sure that we have consent, even if the transfers are to non-affiliates. One of the solutions or the compromises that I've seen are listing out bad players, that in other words, the investors can't transfer to these bad players without general partner consent. I think the issue with that is that the bad players of today aren't necessarily going to be the bad players of tomorrow. And so in your ideal world, if your partner is going to transfer to a non-affiliate, you really want outright consent. and that's it for me. I don't have, luckily, any horror stories like David does. But again, these are just certain tips to strongly protect yourself, from having a nightmare exit at year 15, and to make sure that, the sustainability of your project continues. Alyssa, I'm going to turn it back over to you.
Sorry, finding my.
That's okay.
Okay, so this is, before I get rid of the screen share, this is a list about some of the items that we're discussing here, the Washington State white paper, the WBUR news stories on NPR. And so you can get, I saw somewhere in the chat, where am I? I saw somewhere in the chat that, okay, sorry. Okay, everybody back to normal here. I totally lost my train of thought. Anyway, I had a couple of questions. One was, Lauren, you were mentioning that there's often a ROFR and an option. And I know, like David, most of what you were talking about seemed to be disputes about the ROFR. Are there ways in which you can kind of manipulate using the fact that you have both a ROFR and an option? Or how do you kind of using one instead of the other, or how can that play out in a way that's useful?
Well, so I think from my perspective, the Dash experience, in case that I mentioned out in Seattle a couple of years ago, they had a full arsenal of year 15 tools available to them. They had an option to purchase the project at fair market value. They had an option to acquire the limited partner interests based on a fair market appraisal of those interests. And that partnership agreement went on to say, if you exercise your option to buy the limited partner interest, the appraiser shall be instructed as follows: take into consideration restricted rents, take into consideration lack of marketability and lack of control, and an inability to require or force liquidation. Making it real clear that you're buying a bundle of rights that are in a partnership. And so when you go appraise those, the appraiser looks at it and says, okay, well, I'm going to do a discounted cash flow analysis. And that, in those circumstances, produced a price that was more efficient for the nonprofit to acquire the limited partner interests than an option to buy the project at fair market value. They also had a ROFR. But when you evaluated the assumption of debt and you evaluated other factors and exit taxes and things like that, it became the more efficient execution for that nonprofit to exercise the option to purchase the limited partner interests. So they had a really solid contract. But as you saw from the internal email that we looked at earlier, the investor didn't, they're not even an investor. It's the aggregator didn't care. They were looking to squeeze. They were looking to, take them out and, take advantage of what was otherwise, in their opinion, a small nonprofit. And they had leveraged them in 2 deals prior. And so this was like, okay, every time they're trying to exit this aggregator, the price just kept going, right? It's like, okay, well, if they overpaid the first time, oh, they'll do it again. Yeah, they did it again. And then finally, the price tag's like $1 million, and at some point it has to stop. And it did.
Mm-hmm. Mm-hmm. And what are,
sorry, Alyssa, I was just going to say that you want as many tools in your toolbox
right.
for year 15, frankly, as you can get. And that, the projections when you close are just that, they're projections. And at the end of the day, you don't know how your property is going to perform and what circumstances will be. So the more opportunities you have for a smooth exit, the better. So, we try to, cover ourselves for every different scenario and make sure that you have as many rights as possible to have a smooth exit.
And about the GP consent rights, I know we worked on some deals together and tried to get, better language. What do you think is kind of the best that you're getting? I mean, there are still some investors that will agree to have GP consent and leave it at that, and then others fight it. So what kind of variations on that theme have you gotten in recent?
That is the best. We want outright consent if they're transferring to a non-affiliate. I've seen anything from, like I said, specifically listing out bad players, adding certain criteria for, partners that they can that the existing limited partner can transfer to without consent. They have to meet certain criteria. And on the flip side, if they've litigated within a certain amount of, look back, in the, if there has been, I think 3 years previously, litigation, frivolous litigation, and other sort of bad boy acts that you would not want to partner with. That in those instances, the general partner has the right to say, you cannot transfer to these entities.
Mm-hmm. And then I just noticing in the chat, somebody, Elizabeth, had a question. If you have consent, how do you thoroughly research the proposed entity, determine its nature and purposes in a list of bad actor entities? And that's something that, we run into as well. Like there might be a list of bad guys today, but there might be a whole different set of bad guys. So I know we got something in a recent deal that said that, if in year 50, if whenever the time is in year 13, 14, 15, you can prove that is a bad guy, that they don't need to be on the original list, but they get, so there's all kinds of variations on opinion.
100%. And again, the best protection is if it's to a non-affiliate, you have outright consent. So right, that's what I try to push for on day one. But yes, there are a number of variations. You can't obviously anticipate any scenario, but you want, as much consent as you can get.
Right. And David, what about, I guess we're kind of waiting to see what happens in Washington, but from my understanding that they came out with that white paper and then they immediately took action to put into their regulatory agreements that the agency, the commission, has to consent to any transfer of LP interest. And they kind of outlined what they might, where they might reject them. And they immediately got sued by Alden Torch, and that's still going on. And so where do you think that might end up in terms of states, allocating agencies being able to play more of a role in denying transfers to bad guys?
Yeah, I would say, this is my opinion. I think it was a lawsuit designed to bully HFAs and commissions all over the country. Mm-hmm. I know that they, on the other side, have a different opinion, and they can have it. But in my view, and in my opinion, going off and suing the commission and claiming that a state regulatory body administering the housing credit program is not allowed to do so with policy objectives in mind is ridiculous. That's exactly what they should be doing. And WSFIC, in my opinion, has every right to shape policy around their housing stock and the preservation of it in their state. And I believe every state agency and commission in the country not only has that right, but they have that duty as the shepherds of this program that is being subsidized with taxpayer dollars. And so, I'm hopeful that the federal court there will agree with that, because, if the effort of the other side, as articulated in their complaint, is successful, they are just an administering body that is simply supposed to check boxes and, award credits with no policy objectives in mind. And that's bad, in my opinion. Mm-hmm. So I don't know how it's going to turn out, but I would be cautiously optimistic that WSFIC's able to prevail.
Mm-hmm. Mm-hmm. And then let's see, back to the chat. Please feel free to put more questions or comments into the chat. Matt had, I think you've already kind of beaten this dead horse, but Matt had a question about who's behind the change in LP investor negotiating position that GP consent of a new LP is no longer allowed. Is there something in the background there that's
not that I'm aware of, and I'm not going to name names, but again, make sure that you involve your lawyer early.
Yeah. And let's see, there was another comment earlier from Austin saying it's important to negotiate year 15 in the LOI and not waiting until the LPA, which I think is a good point. I mean, like Lauren, you were saying, you can't take all the LPA language and put it in the LOI, but
right. So you're talking about a 10-page document versus right. An 150-page document. But I think some of the points that David highlighted, that have sort of caused heartburn later on are important to get in the LOI, like I highlighted before, the bona fide offer, what can trigger it, et cetera. Those are important to agree upon upfront. I know a lot of the time the investors take the position when they're drafting LPAs, you know, here's the LOI, you didn't bring it up then, you're bound to this, we're not going to put it in. So if it's something that's important to you up front, I would, you know, ask about it and have it put in the LOI.
Mm-hmm.
Hope that helps.
Mm-hmm. Okay. I don't see any more questions or comments. Were there anything, I can kind of think of some more, but David or Lauren or Dr. Logan, anyone have anything that you left out of your presentation that we need to go back to? Or
I don't. I mean, I did put a message out there. You know, I think that for those who are interested, you know, one of the resources that we put in the back of the materials that Elisa just showed was the WBUR has done this 3-part investigative series. And it stemmed from a case very similar to what Dr. Logan went through, where you have a tenant-led organization that was formed in the 60s as part of the civil rights movement in the South End of Boston, who acquired a series of brownstones covering an 8-block radius in Boston's South End. And they acquired these properties back in the 60s and early 70s. And then, you know, 15, 18 years ago, they re-syndicated, they went into the LIHTC program, they got housing credits, they did rehabs, you know, and whatnot. They received a forced sale letter from an aggregator organization managing the LP interests, and they said, go sell the properties. We said, okay, because we have a ROFR. So we marketed the properties, put it out there. The other side looked at it, saw the footnote about a ROFR, and they said, what do you mean there's a ROFR? I said, go check the Suffolk County property records. There's been a ROFR recorded against the property since this LIHTC transaction closed 18 years ago. And we have an offer. We have offers that have come in, and we're executing and exercising our ROFR. You know, the other side is claiming that these brownstones are worth north of $60 million and need to be sold to a third party. We don't think so, and we think we're right. So we're in federal court there. Excuse me. Yeah, we're in state court in Massachusetts. You know, so I mean, these issues are catching the attention of a variety of different stakeholders. And so WBUR got really interested in it. And they've done a 3-part series, the last of which, you know, and I appreciated Matt Swartz's, you know, update on what's happened at Capitol Hill and Senator Wyden, but the last of which, you know, Senator Wyden, he teed off. I mean, they interviewed him and he took a stance and he went on record. And, you know, so we're optimistic. I mean, it's going to take more time, but it certainly got the attention of, you know, the chair of the Senate Finance Committee, Charlie Neal. Congressman Neal is from Massachusetts. And, you know, this is happening in his home state now for a second time, at least. And so we're appreciative of the fact that his office is aware and he's, you know, leading up Ways and Means now. So it's just going to take more time and more awareness and knowledge and discussion and opportunity like this. And I'm just really thankful that we've got, you know, 70 plus people who've hung in here at the end of the day, and they probably love it if I stop talking and they can go.
Yeah. Well, I wanted to get back to the federal. What do you think? Do you think there are approaches they could be taking on a national level that are kind of the most important or most critical that could kind of, you know, try to resolve this nationwide, and instead of having every state have to figure out their own solutions? Or
it seems like it's going to be tough, right?
Yeah.
I mean, it's baby steps, I guess. I'm probably the last person that should be kind of talking about policy and how you can actually make it work. I'm real fortunate to be involved in a variety of different working groups across the country. People who are interested, you know, Ellen Lori Hoffman from the National Housing Trust, she's the director of policy. You know, she's doing an amazing job rallying support and getting working groups going. NCSAJ is looking at these issues. They're very much aware of them, which is really, really important in my view, because more commissions and more agencies, you know, who are administering these programs are aware of maybe things they weren't aware of a couple, 3 years ago. And then Bobby Rosen, a lot of you probably may know Bobby. Bobby's a consultant to a variety of different nonprofit organizations across the country. And when the LIHTC program was being drafted in the late 80s and into the 90s with the amendments that occurred. You know, he was a staffer up there and is principally the architect of Section 42. So there's a lot of talented people out there with a lot of depth of knowledge and resources. For those who are interested and want to get wired into any of these things, I'd be happy to make some connections. And
from what you're seeing, are people, is it getting worse or is it getting better? I mean, are there kind of, are new aggregators popping up who are seeing, hey, here's a lucrative way we can kind of, you know, get some juicy real estate, or are people are court cases kind of going, you know, against them enough that they're slowing down, or what do you think?
Well, I mean, we're fortunate to have had a lot of success for our clients, but, you know, I know that there are other outcomes that haven't been successful. I would say I've seen in the last year 2 brand new organizations pop up that I didn't even know were around. And I certainly believe that I don't know everything that's out there and everything that's going on. It's a great big world, right? So it's a wonderful irony, and it's not even wonderful. I'm not even sure what to say, but, you know, for Dr. Logan, right? We're fighting to get what we're supposed to get, right? For them, it's like a game of Yahtzee. If they win, it's windfall. We just hit the jackpot. Oh, we lost. What do we do? Oh, well, okay. Dr. Logan gets what he was supposed to get. I mean, what? I mean, so, and you know, there's well-heeled, well-funded institutional investment funds out there that, you know, if people are running them and managing them and using those resources in a way to impact litigation, you know, you see it. So I think it continues to grow. We see more and more cases. We see more and more disputes. We see more and more clients calling and saying, hey, can you consult with our deal counsel and help them with best practices based on the things you've learned in litigation? Absolutely can. But to Lauren's point, we don't know who's going to, you know, sell their portfolio 2 years from now to the next aggregator, right?
And it's scary when there's somebody, you know, as Dr. Logan explained, you know, Bank of America is somebody that we here in California anyway, know and trust, and, you know, we do a lot of work with, and you know, so it's scary that somebody who's you know, we think of as a good guy, you know, was complicit in setting off the chain of events that were so problematic. And Dr. Logan, do you have other properties that you have developed, or that you're still on mute, sir?
We do, and the year before we were introduced or made aware of Holokeen's intention, we had another property that came up on year 15 where the limited partner attempted to get us to pay them fair market value for their interest. And it was through the threat of litigation, actually drafting the complaint and sitting down with the managing partner of the development firm, where he finally conceded that we were absolutely right and that he was not going to go down the road of trying to take something away from a community-based organization that they contractually deserved and, quite frankly, morally deserved. But he was a local guy, and he had to continue to live in this community. His firm had built affordable housing, and we're in the affordable housing business. But he just saw an opportunity to make money and thought he could take advantage of a not-for-profit. We also have deals that are coming up in the next 3 or 4 years. We're much better prepared. Our limited partners know who we are now, and we are having those conversations before year 10. What is your intent? You know, are you going to notify us and give us notice a year or so before you intend to exit, and et cetera, et cetera. So we're better prepared, and we hope we have more resources in order to ensure that we can fight this. And you know, money has no limits. Greed has no limits. By all means necessary to steal, cheat, and take is sort of the mantra of these aggregators. And we've seen that. We've seen that in them trying to humiliate our board members and trying to freeze any funding or loans that we're looking at getting from banks. They play dirty. And so I think that those folks who are in the affordable housing business need to be prepared to fight, and need to make sure you set aside resources to fight, and to make sure that your board is also educated, because we could have never done this without the support of the board, because this was a risk. We could have walked away with $7 million and the property, not own the property, or we could own the property and walk away with $11 million and then re-syndicate and walk away with another 30 million. So there was the return on the fight was very high, but the risk also was potentially devastating, in the sense that we spent $2 million that we didn't have set aside for litigation, that we've been delayed 2 years in getting what's rightfully ours. And it also froze some of the other deals where we were trying to get lines of credits and things of that nature because of this litigation. So you really have to be prepared to fight, and your board has to be with you. Mm-hmm. The only way they can be with you is really to have an in-depth, at least the leadership, an in-depth of understanding of the rights, of the contract, and the value of what they're fighting for.
Mm-hmm. Mm-hmm. A couple of the quick things in the chat. Richard pointing out that in addition to the LP transfer terms being in the LOI, they should be made a key deal point in the investor selection process. And absolutely, that's something that we require in RFPs or whatever, to have investors comment on that at the outset, so we know where they stand on that. Good advice. And then Alice was asking, are there any of these aggregators that are also originating new deals, or are they all just focusing on buying existing LP interests? Are they doing any new deals, David?
Typically not. I'll say that, when I kind of coined this term, initially it was people who were not syndicating new deals. And they weren't concerned about relationships, and they weren't concerned with, what they burnt down on their way out the door. But what I have seen is there are organizations out there now that seem to be trying to syndicate new deals. And they are syndicating new deals, but they have a portfolio or portfolios of older deals that they have acquired from elsewhere that they were not the original investor in. Mm-hmm. And so they're doing that aggregator playbook in those deals. And they're trying to syndicate new deals. And so I think, one of the concerns that I mentioned earlier is there are traditional tax credit syndicators who are continuing to syndicate new deals that in some respects are saying, hey, look, I want to have a hard conversation about my exit. I'm not going to be as bad as those other guys over there, but I do have some expectations based on what I'm seeing them do that I think I should be able to get from you. Mm-hmm. And I will say, I think it's important on all of us to recognize the program works. Right? I mean, it has these things going on, but we can't shoot down the program, right? Because it's this real symbiotic relationship. Like people who might be familiar with golf or some other discipline. Self-regulation is important, and it's incumbent upon all of us in this industry that depend on affordable housing to self-regulate. Let's see what we can do. I mean, we certainly don't want certain people up on Capitol Hill to say, oh, there's another public subsidized housing program that failed, so let's just kill it. That would be awful.
All right. Okay. Well, I know it's coming up on 8 o'clock on the East Coast, and you two have some kind of reception you're supposed to be going to, right? Some wine and cheese or something like that that's waiting for you.
Well, now we're thinking about dinner. The reception, I think, is over. I don't know about
okay.
Maybe not actually in the same space, just different parts of the same space. And there's been an offer out now, David, to go to dinner.
Okay. All right. Well, I want to thank you on behalf of all of the 75 people or so who have been on the session. Very much appreciated. Lots of really good information. I want to encourage everybody. You can go to the WOBA platform thingamajig and get the PowerPoint if you want it, and it's got those resources attached to it. So thanks very much. Really appreciate it, and hope everybody enjoyed the whole conference.
Thanks, everybody.
Thank you. Bye-bye.
Thank you.